and on TuneIn, iHeart, and on Odyssey. This is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Top of the morning, Dan and Amy. We mentioned this in our conversation with former First Deputy Assistant Cook County State's Attorney Bob Milan yesterday. And I think it bears repeating. I don't know that we emphasize this enough. Both legislative leaders and the governor are attorneys. Don Harmon, Chris Welch, J.B. Pritzker all have law degrees. Some actually practice law, not J.B., but the other two. So when it comes to the purge law, the so-called Safety Act, including version 1.0 that was signed into law to much fanfare by all of those three and their party, they knew what they were doing. And you talk to any professional prosecutor not named Kim Fox or Eric Reinhardt of Lake County, and to a person, they will tell you this would have been devastating to the public safety of every Illinois community. To a person. So because they were compelled to make some amendments out of political expediency after they all survived the November 8th election intact, shouldn't be forgotten what their actual intentions were and are based on what they did with 1.0 and frankly even 2.0, which is now under review by the Illinois State Supreme Court, as we all know. Even 2.0 is not without its problems.
And don't forget that Governor Pritzker made large campaign contributions to two of those judges for them to get onto the high court, so they owe Pritzker a victory because he paid for them to get on the Supreme Court.
And Governor Pritzker has weighed in on the state of play on that judicial proceeding. That, again, the Supreme Court staying the implementation of the law that was scheduled to take effect Jan 1. And now we're looking at perhaps a decision by the state Supreme Court in March.
Yeah, he's not backing down.
Well, just to clarify, the decision by the Kankakee judge was about the Pretrial Fairness Act, which is a piece of the Safety Act. And the rest, and obviously, I signed the law and the legislators voted for it, and there is I think a common and comfortable belief that it is constitutional. But, the court system will, make a ruling on it through the Supreme Court sometime in the next few months. I'm disappointed that there's a delay in the implementation. Justice shouldn't be delayed, and we want our neighborhoods to be safer, and putting the Pretrial Fairness Act into effect will make our neighborhoods safer.
That's his story, and he's sticking with it, Dan.
Of course he's sticking with it, and hoping probably privately that the Supreme Court bails him out of this predicament he put himself in. For more on this, we're pleased to be joined by Kendall County State's Attorney, one of the 100 of 102 county state's attorneys who opposed the Safety Act in its original incarnation. He is Eric Weis. Eric, thanks for joining us again. Appreciate it.
Thanks, Dan, Amy. Appreciate it.
So it seems our conversation with obviously the parties to the suit in Kankakee County, which is 65 county state's attorneys, yourself included, as well as Bob Milan yesterday, is it's pretty clear the Kankakee County Circuit Court judge's ruling is pretty square on the constitutional issue when it comes to determination of bail, pretrial detention, and that on the matter of the law, separating it from the politics, that even Safety Act 2.0 should be held to be unconstitutional. That's your view, clearly.
Yeah, clearly that's, even with the amendments, Dan, we filed the lawsuit under a couple different legal theories, and being part of the litigation team, we've been up front with everybody. Look, we're not opposed to some of the criminal justice reforms. We're not opposed to some of the provisions that are in the act. And actually, some of those actually still survive. Didn't find the whole act unconstitutional, just the pretrial fairness portion. I mean, you've got to do it the right way. when you infringe upon the Constitution, when you step on the toes of the people and try to amend the Constitution by legislation, that's when state attorneys have to step in.
And speak to this infringement that you described. Put it in your words in terms of what exactly this infringement is.
Well, when you look what just happened, when you amend the Constitution, you take it to referendum. We just had that, whether you agree or disagree with the Workers' Rights Amendment, that's how you do it. You take it to a vote, you take it to the people, and they make the decision of whether their Constitution should be amended. And that's how you do that in this case. And they chose not to do that. For whatever reason, I can only speculate. I don't like to guess why people do things, but they didn't do that, and they've infringed upon the rights of the judiciary. And we have a very simple theory of power when it comes to the state and the nation is there's a separation of powers. One part of the government doesn't infringe upon the other part of the government. That's how we keep a good society. And what the legislature, the governor did is they've infringed upon the rights of the judiciary in this case.
Well, what's your reaction when he says that neighborhoods are going to be safer because of this? What's your reaction to that?
Well, I respectfully disagree with that. I think when you take away the ability of a judge to make a determination and you tie their hands of what risk an individual has to be released into the community, I don't know how the community would be safer. I've been doing this 26 years. I don't know how long the governor's been a prosecutor, if at all. But I can tell you that giving judges more tools than less is always a better way to have the judicial system work for everyone.
There's another aspect of this that we discussed with you and Glasgow and others, the time limits that are put on prosecutors to bring cases to trial, lest the defendants be released pending trial. Now, those time limits were extended in the amendment process, so in version 2.0. But they're certainly not as long as, say, they are in New Jersey, where they went to no cash bail system. And I wonder if we still have a problem from a prosecutor's perspective with those time limits that are now imposed if the Safety Act 2.0 were to go into effect, in terms of the resources required to bring the strongest case possible to trial in the time prescribed.
Yeah, I think that again, it goes back to those that don't do this job don't know exactly what it takes to do this job correctly. And everybody wants justice to be done, from prosecutors to defense attorneys to judges to the people. And to do that, it takes time. You can't rush a case, and no one wants someone to sit in custody longer than they need to be pending trial. But the practicality is with DNA, with laboratory results, with gunshot residue, with just follow-up investigative work, the time frames that they put on these cases are just not practical in most cases. In some they are. Some are simple. They're wrapped up in a nice, neat bow. There are 3 witnesses. You don't have any crime lab information, and you could do those cases in 90 days. But that's not the majority. And today's criminal justice system is not like it was 30, 40 years ago. We have all this technology. We have all these body cameras that are part of the Safety Act. We have these things that ensure that the right person is in custody. And to do that, it's going to take some time, and it's going to take longer than 90 days. And having this, what was originally an automatic release in 90 days is just ludicrous, to be blunt. There's just no way in most cases that that's going to work.
So we're still going to potentially have a problem. Yeah, right. That's what I mean. We're still going to have potentially a problem in the 2.0 version of people being released that should not be, in a prosecutor's mind, released pending trial.
Yeah, and it doesn't give the judges the discretion as to allow, for example, the prosecutor to come in and say, we've got these laboratory results on a very serious sex assault case, and we want to get these results so we know for sure, and we have everybody, justice is being done. It doesn't stop the clock, and that's the problem. Is that it's not a practical solution to a problem that can be easily addressed if done the right way.
It just as an aside, I mean, it's remarkable too, because this is a bit of a political statement, so you don't have to comment on it. But the hard limits they want to put on pretrial detention for those they even would allow to be detained at all. Yet when it comes to people who engaged in vandalism or rioting on January 6th, I don't hear any comment about people at the federal level being held pending trial for a year and a half for much lesser crimes that they're even charged with than we're talking about here, and that's with all the resources of the Department of Justice and the federal government too. So I just, the interest in no cash bail and the interest in pretrial release of criminal defendants is very different depending on the politics of the situation. Per these individuals that we're talking about, responsible for passing this law in Illinois, and I think it's worth noting that just because of how political this actually is, as much as they want to pretend that it's not political. Their motivations are strictly political, I would argue, and I think that highlights the point, their difference of opinion as opposed to what they want to do locally versus what they would support or not support federally. One other piece of this that I want to talk about, because you mentioned that the Kankakee Circuit Court judge did not rule the law unconstitutional in its entirety. The impact it'll have on policing, since you work closely with police per the investigations they do and the evidence they collect, so that you can take it to trial. There was some concern expressed, and I know there were some police organizations that eventually came around to support it. Maybe that was partly politics too, but some concern about rules of engagement, about the training requirements, as well as the sort of investigative oversight of police via things like this anonymous hotline that's part of the law. What's your perspective on the police portion of the law?
I think, like you said, there's some good parts of the law. I don't want to sit there and tell you that everything is bad. I said, body cameras, for example, are a great tool. They protect law enforcement in 99% of the cases from false accusations or false allegations of misconduct in most cases. So most law enforcement, I think, support those type of things. They support training. They support things that always allow us to do our job better. And I'm speaking law enforcement in general. I know when it comes to anonymous complaints, those type of situations, that's starting to push the envelope. And I understand that we want to encourage people to report misconduct, but there's got to be some accountability. I mean, if I said, hey, and I'm not going to tell you who I am, but Dan Proff is a insert thing here, or Amy Dix is a person here, and this is what she or he did wrong, and this is why, and that goes in your file for the rest of your career. But nobody knows who you are, and nobody knows why, or if you have a vendetta, or if you arrested someone in my family, or did something. There's got to be some accountability and a way to substantiate those type of complaints without ruining someone's career for absolutely no reason. We don't do that in the criminal justice system.
Right.
You can't file
but
an
you can't
anonymous,
get that expunged from your record either.
Well, also too, I can't go. If I file a false police report, then I face legal repercussions. If I file a false complaint on the hotline, I don't. Where's the sense in that?
You can go to prison for filing the false report, and nothing will happen to you if you file a false one against an officer.
That's ridiculous.
Right. No, exactly.
And nothing's been changed in that, huh? It's still the same way?
Nothing. Well, yeah, the Safety Act portion remained. I mean, that part was not addressed. The only thing that Judge Cunningham addressed in his ruling of unconstitutionality was the issue of the pretrial fairness portion.
Okay. Right. And this is something too, importantly, just as a reminder here, another stakeholder in the criminal justice system, in addition to the public, but on the professional side, sheriffs. You had the county sheriffs were aligned with county prosecutors throughout the state on this as well, for the same reason. They're not interested in seeing people accused of violent crimes, in many cases not for their first time, being released either.
Correct, and that was a good partnership with law enforcement. They both, prosecutors and sheriffs realized that, this is bad all around for everyone. And so it was nice to see it wasn't just prosecutors complaining, it was law enforcement in general as well.
What about the 1/3 of county prosecutors in the state who did not join the suit that was filed and adjudicated in Kankakee County? Internally, to the extent you can speak to that, what's the divide there?
Well, I know that there were some that wanted to sit at the negotiation table to try to get, as you put, version 2.0. If we were unsuccessful in the litigation, that we would have a more workable pretrial fairness portion. And they were successful in getting some of the changes that were the egregious issues in the, I'll call it, as you said, 1.0 done. At this point, there's a finding of unconstitutionality. I hope that they would join in with us in support going forward with the Supreme Court and showing their support that this is unconstitutional and agree. Getting 102 of us would be great. I don't expect that will actually happen, but the vast majority of prosecutors, including those that didn't, would join in supporting us in the Supreme Court. I know several of them filed for temporary restraining orders in their own county that were granted prior to the Supreme Court issuing their stay of the pretrial fairness portion of the statute. So there's some encouragement that again, people have to do things for different reasons, and I respect that. Maybe not always agree with it, but I respect it. And hope going forward, now that we have a ruling, that we'll get everyone on board.
Yeah, if your county state attorney is one of the 37 who didn't sign on, you might want to call the office and see where they're at now that it's been held, that portion has been held unconstitutional, and encourage them to get on board, because 37 initially were not. He is Eric Weis. He's the Kendall County State's Attorney. Eric, thanks as always for joining us. Appreciate it.
Appreciate it. Just have a good morning.
Thanks, you too. And he joined us on our turnkey.pro answer line.
You're listening to Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
During the pandemic, they closed our churches down.
Suicide rates are exploding. Drug and alcohol use is ravaging America, and there's no church to bring the hope.
See the new documentary, Super Spreader, how a stand against religious tyranny brought hope to a country in crisis.
Christian singer and activist Sean Foyt leading what's called Let Us Worship.
Here's a move of God that's going to change America.
Watch Super Spreader, available now at salemnow.com. salemnow.com.
If you are 65 or older, you know this. Watching your hard-earned dollars fly out the window on healthcare costs is so frustrating, but here's some great news. If you missed the December 7th deadline for open enrollment, it's not too late. Here's something that can really help. It's MediShare 65 Plus. MediShare is a community of Christians who share each other's healthcare bills. It's people who encourage and pray for each other too. MediShare 65 Plus is a low-cost option for those with Medicare Parts A and B, and it fills in the gaps where Medicare stops. It's a great way to fight inflation, too. You can lock in one low monthly price for up to 10 years. Plus, it's easy. You can use any Medicare-approved